All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for argument in case number CR220387, State versus Sidor, if I'm pronouncing that correctly. First, I would note that, as you can tell, there's only two of us here. Judge Goss is unable to join us. However, he's going to be participating remotely, and he will, attempt to convey any questions he might have through us as with our devices. So if we seem just a bit distracted, it's not because we're looking at something else. It's for just monitoring a little bit to see if he's emailed us a question or two. Counsel, please keep in mind we're recording the argument, so please identify yourselves and who you represent at the beginning of your arguments. Each side will have 20 minutes. Appellant's counsel, you're responsible to watch the clock and reserve as much time as you desire for rebuttal. Also, please keep in mind we've read the briefs, we've studied the record, we've also watched the video that is relevant here and discussed this case in conference. With that, counsel for appellant, you may proceed.
Thank you, Your Honor. May it please the court and opposing counsel, I'm Virginia Cruz. I continue to represent Mr. Sidor from the Hamp Law offices. We handled Mr. Sidor's case at the trial level as well. We had one, and we were hoping for a second, motion to suppress hearing there. The first prong we asked the court to consider was that the traffic stop in this case was prolonged unlawfully. We asked the court to find that the trooper in this case did not possess a reasonable, particularized or objective reason to continue to detain my client further. At the hearing, while we didn't concede the reason for the traffic stop, we certainly understand the court finding that my client was following too close when he was initially stopped. And I know and I appreciate that the court has reviewed the relevant portions of the Axon video in this case. I think it's pretty clear that almost immediately Trooper Wilson in this case went into what we would call interdiction questioning. I think it came out in the motion hearing, if not the trial, but Trooper Wilson is an Arizona Department of Public Safety employee who now has a K-9, but at the time was part of a border strike force, which is an interdiction team. Their primary focus is making traffic stops along the highway and other safety corridors.
Counsel?
Yes.
Let's say that the trooper stopped Mr. Sidor for 10 minutes, and that was the reasonable period of time it would take to run his papers. Would it be a problem if he used the whole 10 minutes on interdiction questioning if the time period was not extended thereby?
If the purpose of the traffic stop would have taken 5 minutes or 8 minutes or even 9.5 minutes, absent the unrelated questions, I think it's still a problem. The fact that this happened in 12 minutes or so where a warning was issued, I think what the court looks at is, was it prolonged unnecessarily by unrelated questions? So even at the trial level, we didn't oppose the notion that questions unrelated to the traffic stop could be asked, but in this case, the entirety of the questioning had to do with the trooper's subjective belief that my client was involved in something unlawful. So if he'd cut out any percentage of those questions, this would have been a much quicker traffic stop resulting in a warning, probably would have taken no more than 8 minutes. So I think what
How do we know that? How do we know it would have been 4 minutes faster without the interdiction questioning? How do I conclude that if I wanted to conclude that?
I think you, from watching the video and listening to the audio, because obviously you can't see the officer in the video, but when you think about his divided attention and the effort he's putting into asking questions, again, unrelated to this traffic stop, the trial court even mentioned, this isn't a case where it was in a very rural area, even though it was northern Arizona. There was no reason to believe that there was a delay in getting information back from dispatch that we get sometimes up in the northern part of the state. There's no reason to believe that very quickly he did not get the return to see that my client had a valid license and everything was in order with the registration of the vehicle. So again, this should have been even a quicker stop.
So the fact that his detention was divided is what you would kind of hang your hat on. That's really what it was. It made it go slower because he was spending all his time with the questioning. So it's just sort of obvious from watching the video, you would say that it could have been 8 instead of 12 minutes or something like that.
Yes, Your Honor. And I think it's clear from my client's responses to the officer, he more than once repeated that he wanted to be on his way.
We have harder questions for you, so let me give you another one, sure, because that one was less concerning. The biggest concern I have is, what's your best argument that the prior trips taken arguably as a pattern with Mr. Sidor's trip don't create a basis to detain him past the point when the stop is otherwise over? That's really the crux of it for me, at least, where I am today, so can you help me with that?
Sure. Well, kind of two-part in my answer, and I'm happy to address either one or in any order. I think the problem we have is that that information was accessed and relied upon by the officer that directed his questioning to my client, and the officer, admittedly in his testimony, waited between 4 and 6 miles to pull my client over until that license plate query returned to him so that he had that extensive information to direct his questions.
I apologize for interrupting, counsel. Let me separate. I didn't want to ask both questions at once. There's the question of, does the arguable pattern of trips constitute probable cause to detain him? And then there's the whole propriety of how we got there, like what you're speaking to, and that's a totally important point too. Could you please speak first to the pattern, whether it's sufficient or not?
Sure. I don't think it was sufficient. Very quickly in the questions to my client about his travel pattern in that vehicle, he was very upfront about it being his only trip in that vehicle, the fact of the short duration and turnaround time, the purpose of his trip. Nothing he indicated to law enforcement was inconsistent with that travel, that last trip that showed up. He gave, and I know the court's aware, but he gave the reason that he was going to pick up a puppy. That would only seem to need a very quick turnaround, and there was in fact a puppy in the vehicle with him. So again, nothing about my client's, even if the court finds it was okay for the officer to ask those questions and run that search, nothing from my client's responses should have kept the investigation going any further.
So what about just the fact that the car itself this vehicle had made at least those 2 prior trips? At least we don't know the exact details of those exact details, but we know locations where that car was noticed. Doesn't that provide more than just a hunch?
No, I mean, there is no reason to believe that my client was related to the vehicle on any other trips, and there was no reason to believe that those trips had any negative purpose that would concern law enforcement. Again, that goes to the overall concern of license plate data and it being able to show people's travels, and have law enforcement try and infer anything about associations or trips or other information that would typically be private to individuals outside the technology that the law enforcement used in this case. And again, my client offered that this was the only trip he had taken in that car, how he'd come into possession of the vehicle, and there was nothing in his responses that the officer followed up on as far as my client's offer to contact his friend, provide that contact information, that who he borrowed the car from. Again, it was just the assumption that he was doing something unlawful for whatever reason, that he had been the person in this vehicle more than once, and then that further assumption, which could have been ferreted out a little bit better by law enforcement if they'd taken my client up on his offer to contact his friend that he received the vehicle from.
What's your best argument that the diesel data should be suppressed in the first place, that the officer shouldn't have been entitled to know about the arguable pattern?
Your Honor, and we haven't found other cases on point, but we're asking this court to go along the lines of other technology that the courts have viewed in the past. And, obviously as technology goes much quicker than courts and legislatures can catch up to, I think the diesel and use of that falls right in line with that, where we're not arguing that as a tool, it should not be available to law enforcement. We're simply arguing that it should be viewed as other technology has been viewed by the courts, where reasonable suspicion should be articulated by an officer before it can be utilized. And that goes back to just the Fourth Amendment privacy concerns for everyone. This isn't just, one dot on a map to tell where a vehicle had been. It's a nationwide network of cameras where billions of scans go into these databases, and it's the one we're talking about in particular, Diesel, is the information is collected and maintained by the federal government. And when you look at the exhibit we put in at the motion to suppress hearing and think of the officer's testimony, even the DEA with their database has a couple thresholds. I couldn't go in as an individual, you couldn't go in and access this, right? Law enforcement has to provide their credentials to get a login. And then on top of that, before a query is run for any license plate, there are 5 specific drop-down categories.
And counsel, we read that and we appreciate it. So does it matter if the officer lied fundamentally? Because that might distinguish this from some other cases out there.
I think it does, because again, I would not argue that ALPR should not be used by any officer. I think it's a good tool for law enforcement. Our problem in this case and cases like this is the agency has no protocol for accessing or running plates. And then on top of that, officers, that leaves them to have just unfettered access to run every single plate of every vehicle they encounter. And at the time of this stop, the officer was having to manually enter the license plate before initiating a stop or after. Now they have automatic readers.
Did the officer lie when he entered in, when he chose the drop-down item, that he already had a reasonable articulable suspicion that the vehicle was being used in drug trafficking or bulk currency smuggling, whatever that was? Is that a true statement? Not a true statement? What does the record show us about that?
I believe that was not a true statement because what he would have selected was that particular plate was associated with narcotics trafficking or bulk cash smuggling. And at the time he entered the plate and clicked on that choice, it was in response to him being trained to always choose that rather than this being a reasonable suspicion in this particular case. At the time he entered that, the only thing he observed of my client was that as he drove past with the car with out-of-state plates, the only thing he observed was my client's hands were at the 10 and 2 position.
Sure. So if that makes it a lie, let's assume it's a lie. Let's just say, okay, I agree with you, that's a lie. What is the impact of, and Judge Goss would like to know as well, what is the impact of that if it's a lie on our analysis? What do we do with that?
Right. I think that's something that the court at the trial level should not have considered in deciding if this particular officer had reasonable suspicion to detain my client any further.
Well, we let police lie in interrogations, don't we?
True, but we don't let police lie when they're supposed to articulate reasonable suspicion grounds. It's not a high bar, right? If he had other information, what we see in other cases is officers decide to run a license plate query after they've had contact with drivers, and maybe they come up to the car and they see multiple cell phones or something about their story doesn't make sense. But in this case, all he saw was my client driving in a proper driving position before he made that claim and ran it.
Well, that's why it's a lie. Okay, so that's why it's a lie, and we let officers lie sometimes, but when you say he should have had to have this reasonable articulable suspicion, that rolls up to a Fourth Amendment standard. So doesn't this whole discussion beg the question of whether Mr. Sidor, had a constitutionally protected Fourth Amendment interest in having the search not done? In other words, that it be some sort of Fourth Amendment search. Doesn't the argument fall unless it's a limited search under the Fourth Amendment?
Well, and I think that takes us to Carpenter and cases in that line where the trial courts are the ones that are given the power to really safeguard Fourth Amendment rights as technology advances, right? This isn't just obviously Mr. Sidor, it's everybody who's on a roadway. There's stationary cameras, there's mobile cameras, there's officers inputting information, and it's going into databases where under this, at least how DPS is doing it, anyone can access it without giving any reason. And that's a privacy concern for everyone because it gives your driving patterns, Officers would take that and use it and say they have a hunch of criminal activity and things that could completely be innocent, but more than that, should be protected. This is technology that gives so many data points to officers that no regular officer, no human would be able to observe without the access of these computers and databases that give billions of hits. In Mr. Sidor's case, right, it's 3 or 4 trips we're talking about, but this data, if it's allowed to be accessed without any barrier, it's allowing law enforcement to see patterns of driving with no duration in time, right? As long as a plate has been on your car or associated with the vehicle, nationwide information that, again, we're not saying shouldn't be used as a tool by law enforcement, but there should be at least a threshold. And if the DEA didn't believe their database should have a threshold, I don't think they'd have a drop-down menu at all, or have the note that's capitalized about the officer avowing what the reasonable suspicion is.
If it is a thresholding, okay, and my prior question presupposed it needs to be a Fourth Amendment search because he needs to have some violation of his expectation of privacy, otherwise it'd be a lie that violates no real expectation. This is a Fourth Amendment search because it's like Carpenter and CSLI, that's basically your position?
Yes, I mean, that's our basic position, again, that this technology is allowing law enforcement to have information that they would not be able to just observe and collect on an individual basis.
Have you thought about how that might square or not with our Supreme Court's decision in State versus Gene? Neither side cited that. That was somebody placed, a GPS tracker on a car. It was a closely divided decision. Do you have any thought about that?
Not about the case itself, but the theory, though, sure, I think it could be seen akin to GPS. Maybe less so, because GPS is a constant monitoring, right? So I think that's probably why that would rise more to a level of a warrant being needed. But in this case, again, the low bar of reasonable suspicion, probably the lowest bar that could be employed should be as that basic first safeguard to keep up with technology.
So you're not asking for a warrant requirement, that this
No.
court find a warrant requirement. You're asking that there be an imposition of a reasonable suspicion requirement.
Yes.
Can you give us, off the top of your head, a quick example? Like, this seems to be an important law enforcement tool, or becoming more important at least. How would an officer sitting on I-40 implement that? I mean, give us a for instance.
Sure. I think we see it out of Fraser or I've seen it out of Virginia and then out of Utah, where law enforcement runs the query after they've had some interaction with the driver, and that seems to make more sense. If in this case the officer had waited to run the query, had stopped my client just for, even if it's pretextual, but for the stated traffic violation, the moving violation, had gone up to the vehicle, my client seemed just overly nervous, didn't want to share where he'd come from. If he observes, there's 4 mobile devices in the vehicle for one person in a vehicle, and had other information, and then he goes back, and as he's running, my client's license and registration for wants and warrants is also at the same time just quickly seeing the data for a license plate reader. I think that's a different situation, and I think that's what we see in other cases is where it has been challenged is the timing is in a different order. This is a case clearly, again, where the officer, I don't think there's any question about it, waits until he receives that return before he initiates the traffic stop.
That was his testimony, certainly.
Yes, yeah, and I think it's consistent with how many miles passed from him pulling out of the median before he initiated the traffic stop. And if it's okay, I'm going to reserve the rest of the time for...
Certainly.
Thank you.
Good morning. Good morning. I'm Jacob Lyons, an Assistant Attorney General representing the state in this case. I'd like to start by talking a little bit about that automatic license plate reader. Now, unfortunately, most of what we've heard about the ALPR and that diesel database is not in our record. What we have in our record in this case is, and admittedly, it would be a much more interesting case if there was a massive collection of data concerning this license plate. What we have is an exhibit that shows 5 hits over the course of 2 months. This is nothing like the cell phone data in Carpenter. This is nothing like GPS.
Counsel, there's kind of a funny paradox in that position to me, because the idea is that the pattern is sufficiently identifying to constitute a basis to detain a person, to, ratchet down their liberty interest, but apparently the pattern isn't really interesting enough to make it like Carpenter. That seems like an internal contradiction in the state's position to me.
Well, I don't think it is so much a contradiction, because if we look in Carpenter and we see what the court talked about, they talked about it's kind of ridiculous what you can learn from that cell phone data. I mean, you can look at someone's whereabouts over, by the minute. You can track their whereabouts, and the court there concentrated on you can basically tell where they are at any point as long as the phone is turned on, and you can go back in time, you can get this data. It's easy to get, it's easy to store. And what we have here is perhaps there will be some point at which there is an automatic license plate reader on every intersection. We don't have that in the record. I don't know how many there are. That wasn't in the record. This wasn't in the evidentiary hearing.
Right, but your point, which I might have led with that too, if I were doing what you're doing today, I said, well, look at how narrow the record is, but isn't the whole theory of stopping him past the 12-minute mark that you have a signature of 3 identical trips from Minnesota to Los Angeles? So isn't that signature very precise in a Carpenter-like way? I mean, that's kind of weird.
Well, what we have is we have these strange, and I'd like to also remind the court that the trooper at this point was at the point that the stop was extended to wait for that canine. The trooper had a lot more than just those trips. The trooper had a lot more factors that he was considering for reasonable suspicion. And the court identified For instance,
what do you think is most compelling?
Well,
we've watched the video.
We've got the extreme nervousness. We've got the force of that.
We have the right to disagree. I disagree.
I do too.
I would say if the court is independently looking at that, I would say that's a thin reed to rely upon, simply because we don't see, for example, we don't see what the officer saw when he first walked up and saw him. Now, if you look in the transcript, you see the testimony. The attorney asked the officer about nervousness, not at the point he was out of the car, but in a narrative fashion, they're talking about as soon as that stop started. I think the most reasonable reading of the record is to say he noticed that extreme nervousness there. He could see the carotid there. It wasn't just later in the video when he asked him to pull the gator down. The gator didn't go on until he was out of the car. He noticed extreme nervousness. He noted 4 cell phones, which that is not normal, and that is also something that is characteristic of drug trafficking.
At trial, did he testify to 4 or 2?
I believe he said there were 2. He said there was one on the dash, one in...
Okay.
I went through and I counted. I could be wrong, but I believe there were 4.
I thought his trial testimony differed from the suppression, but I could be wrong.
Well, and I was just going off of the suppression hearing, since that's what we're considering. So there are multiple cell phones. There were various other things. The fact that he had he'd driven all the way across the country to LA, turned around, boom, right back. Now, could there be an innocent explanation for that with the puppy? Sure. But as we know, we're looking at all of these things, and we don't just discard them if there's an innocent explanation for them. We're looking at the totality of the circumstances. The equivocal answers to his questions about is everything in the car well, as far as I know, or something along those lines. But he also had a fair
answer. It's not his car. I'd probably say the same thing.
That is true.
Might say
that is true. And again, we could go and we can parse all of these things out. But then, of course, we've also got the fact that he's driving Jason's car. Well, it isn't Jason's car, or he got the car from Jason. Who's Jason? A friend. Well, who's Christopher? Oh, well, Christopher's the guy that Jason got the car from. So apparently Christopher is comfortable with allowing a North Dakota resident, as it was also shown in the record, that he doesn't know, to borrow a car from another guy. So a lot of strange things that in this officer's training and experience are indicative that something is going on here. Namely, I think this guy went to LA to pick up some drugs and take him back.
Do you think he has that reasonably without the pattern of the prior trips?
I think he does, even without that.
Even without.
I think all of those add up.
Go back to the prior trips. Do we know who owned the car at the time of those prior trips? I mean, the record does not show ownership of the car back in October.
I don't believe there's
or
any mention of that.
I mean,
I don't believe so. But again, the fact that, someone other than the owner is driving this car cross country, and I mean, these are just all things that are red flags, one after another after another. Now, does any one of them say, bam, the guy's a drug smuggler? Well, probably not. But you're adding up a whole bunch of these things, and you're thinking, okay, this is more than just the spidey sense tingling. This is not a hunch. This is, this is reasonable suspicion to believe that drug trafficking is occurring.
Let's talk about the Alper cases. I think there's some good news and bad news for you in the Alper cases, and
Okay.
I'm going to assume your familiarity with them, even if they aren't all here, and if that's not fair, then I apologize. On one hand, no one has held that the use of an Alper database like Diesel is a limited search under the Fourth Amendment, right?
Correct.
Okay. But in the cases I read, every single time, the people who are using the Alper database already had a reasonable articulable suspicion, and the court made it clear that they already had a Fourth Amendment basis to be sort of in the cookie jar to begin with. Your guy didn't. What do you do with that?
Well, we just go back to whether it's a search to begin with, under the fourth, that threshold question, and that's exactly what Carpenter was about. Is this a search? Are we even going to put it in that category? And I just don't. We have a very clear proposition of law that you don't have a reasonable expectation of privacy in your license plate. Okay, we can start with that. Well, what changes that principle? Now, in this case, they're contending that what changes that principle is the technology and the accumulating this. Now, in Carpenter, the government argued, well, you could have someone tail the person 24/7, okay, which is, kind of a silly argument. Theoretically, you could have someone tail a person 24/7, sure, if you want to spend all those resources. And theoretically, we could say, same
and
thing
that would
with
be
this.
fine. Did the court say that's acceptable?
I'm not sure the court said yes or no, that's acceptable, but I think if it came down to it, I think they'd be hard pressed to say, no, you can't have a detective.
What if it was a drone?
Cover.
What if it was a drone?
What if it was a drone? Well, that would be a fun question as well, and I think we'd look to Carpenter and say, with Carpenter, they really emphasized the sort of the pervasiveness of how easy it was to get this data, how it's on all the time. It's tracking you all the time. It knows it's pinging off that cell phone. If it's on, it's pinging it.
It's about
and recording it.
quality or quantity. Let's just, for argument purposes, say that this came back 100. We had 100 hits. 100 different places. So you could,
Right.
we could get out a map and it would be dotted over all the way from Minnesota. Just multiple times.
Right.
And any difference that the owner of that vehicle or the driver would have a reasonable expectation of privacy. Would your analysis change at all?
Well, I think it'd get a lot more difficult under Carpenter, because I think Carpenter really was, Carpenter
pinging
was
off of
about
cell
quantity.
sites. It's pinging off of cell towers. Isn't
Yeah.
it?
And so that was, I'll tell you what I would look at. One of the first things I would look at there would be, of course, standing. He told the trooper this was the only time he'd ever driven this car before. So at most, of course, I even mentioned in the answering brief, we've got 2 or 3 of these things coming back on the database.
Does that cut against the argument that there's reasonable suspicion a little bit?
No, simply because it is very
We don't know if he
strange
was driving the
to have a car.
We don't know where he went or if he was driving the car. We know the precise time.
Correct.
Precise time, apparently, where it flashed
Right.
the license.
Right. But no, I don't think that hurts reasonable suspicion at all, because it would indicate that someone was driving this car. Would it be reasonable to think, someone is allowing someone else to drive this car because they're paying them to pick up a load? I mean, so I think that having a different driver doesn't detract from the multiple trips factor at all.
I want to give you a chance to comment on something Carpenter-related, because in looking at the other Alper cases, even the Massachusetts Supreme Judicial Court found the use of Alpers there wasn't like a Fourth Amendment search, although it allowed that it could become like one. The Seventh Circuit in Tuggle, Judge Flom, really good judge, wrote this long thing about how concerning it was, and yet it wasn't. In that case, it was like a poll camera, so that wasn't the search. But Carpenter is about your ability to look back in time, which is the point of CSLI data. It's also the point in Gene of the GPS data, which was just 2 days in Gene. Here, the government got to look backwards 60 days and got to look into multiple states. Isn't that much more Carpenter-like than the facts of Tuggle or the facts of the Massachusetts case?
I just don't see it being, and at this point, again, I'm going to have to go back and harp on the limited record that we have. We simply have a few data points here. Now, do those data points support reasonable suspicion? I believe they do. Do those data points turn this into a Fourth Amendment search? I don't believe they do.
That was my question to other counsel as well, and it's so unsatisfying to think that something is particular enough to deprive an American of their liberty interest, but it's not so particular to give them a reasonable expectation of privacy. It exists in this awkward intermediate space where the government can say, aha, I see a pattern looking back 60 days, but nobody really has a right, because it's not super comprehensive of a data set. That's awfully internally contradictory to my way of thinking.
I will grant that it is theoretically unsatisfying, but that is the state of the law.
Counsel, shifting back to how the officer accessed this. First, does the state concede that the officer had no reasonable suspicion to type in the license plate and access diesel? I mean, does the state agree with that?
I agree with that.
Okay.
At that point, he has.
Okay, so to
what
take
he looks
that,
like driving.
right? So the officer, okay, go with me here for a minute. So it lied. I mean, when he picked the drop down that said, "I have reasonable suspicion to believe there's drug activity," or whatever the rest of the statement was. How do we condone? I mean, how is it that we can condone an agency policy? Which I don't know if there's a policy, but that's what at least he's doing, where we're busing a person lying to get into a system that has rules. I don't know. Those are the 5 rules. You're right. The screen is all we have. Those are the 5 options, and he picked one that's not true. How do we condone that? Or why would we?
Well, first of all, I have to challenge the premise of the question in that I don't think the record shows that he was lying. I think he'd been...
Well, you just conceded that he didn't have probable cause. That would make it a lie.
Well, but I think we all understand a lie is different from error. I don't think he intentionally was trying to deceive. I think he had been told, this is what we do.
I thought he testified that he does it in every case.
He testified, I choose this because that's what I'm doing. I work drug interdiction. I believe that's what the transcript said. And that's what he'd been told to do. Now, this is an interesting thing. I'm sure all of us have seen officers say very inartful things that later they realize perhaps their supervisor could explain it better, but they misunderstood it. I don't know. The record on this is pretty thin. We don't know what the DEA, if the DEA had a policy, we don't know
It's Fourth Amendment
what the
language,
policy
counsel.
would be.
Reasonable articulable suspicion is straight out of Fourth Amendment case law. The federal government is saying you need some level of Fourth Amendment showing that you're averring that you're making. And we can agree about that.
Yeah, and again, this is from a printout. We don't have any record about if the DEA adopted any sort of policy. We don't know who made this drop-down menu. We don't know anything about
The
this.
federal government made the menu. The federal government made the officer use Fourth Amendment language to get access to its law enforcement data that was used to put this man in jail for 10 years.
And my point is, that's not in the record in this case.
What's not?
Any of that.
The federal government created the drop-down menu. It's a federal government website.
We understand it's a DEA database.
Right, that's of record. I mean, it's a federal database. It's a federal
Yes.
law enforcement database.
Yes.
That's
made
of
it?
record.
did the agency adopt a policy? We don't know. Did an IT guy put together this drop-down menu?
Whoever in the federal government did it, they sure thought the Fourth Amendment was a gating device to prevent your client from getting the information unlawfully. How is that debatable?
I am just saying that our record does not say anything about any DEA policies.
Sure, there's no written policy of record, but the
Or
database...
if it exists.
The database, maybe there's no policy. Maybe all they have is a gate in front that just says, to pass this gate and get my information, you have to tell me you have Fourth Amendment rights to the data. I mean, that's what it facially says.
All right. But I just, even so, a violation of a policy, that let's assume that a policy exists. And let's assume that the policy, well, I don't even know what the policy says, but the black letter law shows, as I cited in the answering brief, statutory violations don't result in suppression of evidence. Unless the statute says, if you violate this statute, you shall suppress. So here we just don't know. And so what I'm saying is that there was no grounds for suppression based on that. We don't know, and again, I am loath to say that the officer lied. The officer could have been poorly trained. The officer could have been mistaken. I don't know.
He made an incorrect statement.
He made an incorrect statement. I would agree with that. I'm very hesitant to call it a lie.
See, either way, we're kind of out on a limb with this Alper thing because, yeah, there's no case that says the Alper is a limited search under the Fourth Amendment, but there's also, all the cases that don't say that also have somebody who had reasonable articulable suspicion first, and you've admitted he didn't. So this is terra incognita for us.
Okay. Well, and I think what we've got to rely on here is the fact that I think it would be a great stretch to extend Carpenter on this record, to say that it applies here, where even if he had standing to raise all 5 of those hits, which it is not clear, maybe only 2 or 3, the record is rather unclear on that, but even so, does that rise to the level of Carpenter? And I just don't see it. I read Carpenter and how they emphasized the pervasive nature of this data, how it was gathered all the time, et cetera.
What about Gene? Gene was just 2 days with the GPS, and it was the privacy interest asserted by a passenger in a car. I apologize, because you guys didn't brief Gene, so if you don't have an answer, I understand, but I assume your familiarity.
I am,
I mean, doesn't Gene kind of cut against your theory to some degree?
No, because GPS can always send back data as well. I mean, we're talking about, okay, we had some hits in Kingman, one in Seligman, am I saying that right? I sure hope so, and one in Kansas somewhere, okay? We're talking about a vast swath of America that this license plate drove past, apparently, and it was recorded in these 3 locations, or maybe it was 4, maybe there was 2 in Kingman, and it's hard to tell. This is nothing like Gene. This is nothing like Carpenter. It is literally, we could literally say it's the same as having an intern sit on the side of the road with a camera and take pictures of these and then enter them into a database. It's just not the problem that Carpenter talks about.
Do you think going forward DPS should be doing this programmatically?
I'm sorry, what was that?
Running the search in every case, is this a go-forward prudent policy for the officer to continue employing?
Well, I can tell you if I was their advisor, I would probably caution them about it. But at this point, I mean, based on this record, I really can't offer an opinion. If I knew more about how much they're using it.
But it's not a limited purpose search under the Fourth Amendment, and
It is
under
not.
Carpenter, and that's very clear from your point of view.
Yes,
Thank you.
correct. And that's all my time. Thank you.
Thank you again. The one thing I would agree with the state on is it is disappointing, the record in this case, which is probably why we asked for a second hearing as well. I don't know if the record was that clear. I did not interview the officer in a pretrial interview for this case. When I made reference to an interview during the evidentiary hearing, I'd interviewed the same officer in a different case, but it wasn't until the motion to suppress hearing in this case that it became clear that this is something that he does all the time. The license plate queries when he makes traffic stops, that he's been trained, at least on the job, from 2 other troopers to do it all the time. And again, one thing I thought was interesting in the state's argument towards the end was when he talked about, well, there's only a few points, hits in this case with the license plate data, and it's a vast swath of America. And that's the whole point from the defense, is this is information nationwide that an officer, whether it's in Kingman, Arizona, or Yuma, or anywhere, can access, and if we allow it to be accessed without any bar, it's information that they would have had no other way of knowing. And
Would you agree that your client has no vicarious privacy right in the previous travails of this Minnesota plated car?
as the person with current custody of the vehicle, I don't know that I agree with that. And there was certainly no attempt by the officer to check registration or ownership or duration of ownership to test the veracity of my client's claims that he had never driven the vehicle before. So the fact that it was being used against him, I think, gives him the interest in being able to challenge the use of it. And one thing I don't know that I mentioned, it at least seemed to the defense that the trial court judge did a burden shifting on defense when we did raise the issue about with the ALPR and being erased, when he was making his finding and denying our motion and request for a second hearing, and finding that the defense, even if the court found that the trooper had lied, even if the court found that the trooper had incorrectly checked the box, that he did not have reasonable suspicion, the court's comments were along the lines that the defense did not give the court the remedy or tell how there would be a remedy, rather than holding the state to its burden in any warrantless search case of how that was a proper access of information and how the officer acted properly in accordance with the agency, or more importantly, with constitutional rights of everyone.
But that makes it all revert back to whether the Fourth Amendment provides a protection of some sort for Mr. Sidor's right to privacy because it's a limited search. Doesn't it all kind of keep recurring to that?
We do keep coming back to that, yes. But again, in line with Carpenter, I think Carpenter lays it out best when trial courts are reminded of their responsibility to try and at least catch up with technology and safeguard everyone's Fourth Amendment rights to privacy. And I think the ALPR is just a great example of, again, something that could be a great tool for law enforcement, but something that law enforcement should be held to at least a threshold bar to access. Thank you.
Thank you. We thank you both for your arguments, and this morning this matter will be taken under advisement and we'll issue a decision in due course. Court is adjourned.